Oftentimes, I'm representing somebody who has never been charged with a crime before, and so this is their first foray into the criminal justice world and how the court system works. So, I spend a lot of time answering questions about what to expect at particular court hearings. So that's what I figured I'd cover on this week's video, is what you can expect at your first criminal court date. Stick around and let's talk about it. Happy Friday, everybody. Hope you're having a great week and gearing up for an awesome weekend again. This week, we are talking about what you can expect at your first criminal court date. Now, before I jump into the video, as a reminder, I've got a couple of really special things going on that I really need your help with. The first is that I am participating in Extra Life. This is my 12th year raising money specifically for the Children's Miracle Network, and I would love your support. For more information on that, just go to this link right here. It's also down below in the video description. Check out my fundraising page and get ready for a 24-hour live stream that I will be doing on November 9th. 24 hours straight that you can come by, ask any questions you want, details on the page. Now, we're talking about what to expect at your first criminal court date. So let's talk first about some ground rules for this video. The first one, and this is super important, is your mileage may vary. And what I mean by that is we're talking about state courts here. We're not talking about federal courts. I can do another series of videos on federal court hearings. But for state courts, every court is slightly different. Every jurisdiction is slightly different. So as I'm discussing what typically happens in people's first court dates, I'm really talking about around where I practice, the Dallas-Fort Worth Metroplex of Texas in state courts. I've been to other jurisdictions in Texas, and they're very similar. I have not been to many state courts outside of the state of Texas, so I can't really speak to how similar or different they are. What I can tell you is that from what I understand, typically, this is what you can expect in most jurisdictions. But this is why it's so super important to have a lawyer on your side that is familiar with whatever jurisdiction you're charged in, because they will know the little tips, tricks, the nuances of that particular courthouse, and they can tell you if there's anything different to expect in that court. But let's talk generalities now. So now that that's out of the way. The first time you ever appear in court on a criminal charge, this will typically happen well after you're arrested, because from a procedural standpoint, the detectives or whoever do an investigation, or they witness you committing a crime, they arrest you, they send their report over to the district attorney's office. The district attorney's office has to review everything, make sure that the elements of a particular offense are met, that there's sufficient probable cause. If it's a felony, they have to present it to grand jury. The grand jury has to return a document called an indictment. And only after all of that has happened does your case get assigned to a specific court and given a particular court date. So sometimes between the arrest and your first court date, we could be talking 6 months, 9 months, sometimes even a year before you even have your first court date. So this is well after, many times, this is well after you've been arrested. Now, the first time you're in court, that hearing goes by a bunch of different names. Some courts call it a first appearance. Some courts call it an initial appearance. Some courts call it an arraignment. There's a variety of names, but really what that first court date is designed to do is really three main things, okay? The first thing that that court date is designed to do is to make sure that you, as the defendant, understand what you are being charged with. That's also known as an arraignment. When you arraign somebody, when a court arraigns somebody, they are explaining to them what criminal offense they are to have violated. So that's number one priority. They have to make sure that that person understands what they are charged with. Note, I did not say they need to make sure that that person agrees with it, because many times the person does not agree with what they are being charged with. It's not about that. Do you understand, at least at the minimum level, what the state is alleging you have done? Okay, that's priority one. Priority two is the court has to determine where you are in terms of retaining counsel. Are you going to hire your own lawyer? Are you going to ask the court to appoint a lawyer to represent you? Are you going to try and represent yourself? Those three options are given to every defendant, and the defendant gets to choose which they are going to do. If they're going to hire a lawyer, then the court might say, all right, well, I'm going to give you 2 weeks to hire a lawyer. You're going to come back here in 2 weeks and let us know who you've hired. Or if they're going to hire a lawyer and the person already has hired a lawyer, then the lawyer a lot of times is at that appearance with the person and says, Your Honor, my name's Ryan Sandell. I've been hired to represent Mr. Smith here, and I'm going to go and speak with the prosecutor now. We're going to get this process started. If the person is not going to hire a lawyer, let's say they want a court-appointed lawyer, they can't afford one, then the next thing that the court will do is they will give them the paperwork that the person needs to fill out in order to apply for a court-appointed lawyer. It's financial affidavits, it's credit references, that sort of thing that the court needs to evaluate to determine if that person qualifies for court-appointed counsel. If they do, then the court appoints somebody that's on their list of appointed lawyers, and then that lawyer starts the process there. So that's the second option. The third option is if the person wants to represent themselves. Now, this is an option that I highly recommend nobody ever take for any reason. It's just a terrible idea. Almost no benefit can come from you representing yourself. There's a saying in the law that a person who represents themselves has a fool for a lawyer and a fool for a client. And there's a reason for that. There are many, many, many reasons why representing yourself is a terrible idea. And so if you tell the court that you want to do that, the court has to go through a whole list of what are called admonitions and warnings, where they warn you against doing this. They tell you why this is a bad idea. And you have to knowingly waive all of those things and acknowledge you understand them in order to represent yourself. So that's kind of the second step, is figure out where we are on counsel. And then the third point or objective of this first appearance is, if you have a lawyer, for that lawyer to make initial contact with the prosecutor and for those two parties to start engaging in the evidence exchange. As a defense lawyer, I can't do much until I see discovery. I can't do much until I see what the evidence is. And so that first court date is typically my first opportunity to ask the prosecutor to give me all of the evidence that they have in this case. Now, there's a whole host of rules that say that whatever they have to provide to me. So it's not like I have to ask. They have to give it to me anyway. But this is our first opportunity for that to actually take place, for them to give me a disc or give me a thumb drive or whatever. Once those three objectives are met, defendant understands what they're charged with. The court understands what you're doing about a lawyer, and the discovery process has begun. It may not be complete at that point, but at least it has started. Then that's really all that happens at a first court date. The court will then typically reset the case for some time in the future. Sometimes it's 30 days, 45 days. Some courts even do 90 days. And that will allow the lawyers to start doing their work and negotiating a resolution. When you're in most courts, for most jurisdictions, the defendant really doesn't have a whole lot to do at that first court date if they have a lawyer. Typically around here, I will tell my clients, meet me in the hallway outside of the courtroom. I will go in. I will handle all of those things. I will let the court know that I have been hired. I will talk to the prosecutor and start discovery. I will sign whatever pass slips or reset slips are required to indicate that you were present and accounted for and that you understand what we've been doing. And then you get to leave. Your only job as the defendant is to show up like you were supposed to show up. And then your lawyer does all of the work for you. That's why you pay a lawyer to do that. That's why a court appoints a lawyer, is because they know what they have to do. Let them do their job. So there's typically not a lot for you to do at that first court date. So you typically don't have to make any statements. You typically don't have to answer any questions unless it's one of those ones we've already talked about where the court just wants to know kind of what you're doing. You don't have to testify under oath. You don't have to talk to the prosecutor. All you have to do is show up and say, I am fulfilling my obligations to be here as ordered by the court. And that's it. And then your lawyer takes care of the rest. So a lot of times people are stressed or they're worried. Hey, we've got this first court date coming up. What do we need to prepare for? I'm losing sleep because I'm nervous about this first court date. Hopefully this video relaxes you a little bit, because it's really not a lot to it in most cases. What I typically tell people is, if there's a court date coming up that I need you to be specifically prepared for, I'll get you prepared. I will have plenty of meetings with you where I say, here's what's going to happen. Here's what you're going to get asked. Here's what you're going to say as an answer. This is not one of those court dates. The first court date is really just a procedural hurdle that we have to cross over in order to get to the next stage in the process. So I hope that was at least somewhat informational for you. I hope that helped somebody out there. As always, if it did, or if you have any follow-up questions, leave a comment below. I'd happy to answer them if I can, or do another video. Swing by my live streams on Wednesdays or Sunday nights. I try to do them most Wednesday or Sunday nights, unless my schedule just does not permit it. But ask me whatever questions you have. I'm always happy to answer things like that. Hope you have a great weekend. I hope you have a great week next week. And until I see you next time, everybody out there, be good and stay on the right side of the bars.